And I'm going to welcome Ramon to start us off in a good way this evening. Ramon?
Wache. I've been asked to open this up with the song, and I thought I'll do the bear song. And the bear is one of the natural protectors of the land, and this will bring in the bear spirit with us. Okay, I'll start off with 4 honor beats, and then I'll do the song. Thank you for listening.
Thank you very much, Ramon. Unfortunately, I think you were cutting in and out of quite a bit. So Ramon's at a hotel right now, so it might be an issue with the internet there. But thank you very much, Ramon, for starting us off this evening. So thank you all for joining us this evening. My name is Tony Morris, and I am the Conservation Policy and Campaigns Director at Ontario Nature, and I will be your facilitator for this webinar. I'm joining this evening as a settler living in Takaranto, also known as Toronto, Treaty 13 territory of the Mississaugas of the Credit First Nation, and traditional territories of the Anishinaabeg, Chippewa, Haudenosaunee, and Wendat peoples. I'm grateful to live on these lands that have been and continue to be stewarded by Indigenous peoples across Turtle Island. Given the topic of tonight's webinar, I stand in solidarity with Indigenous peoples that continue to assert their rights and sovereignty and express my deepest gratitude to all Indigenous land guardians that continue to fight to protect Mother Earth that sustains us all. So tonight we'll feature a panel discussion from Indigenous rights holders and legal experts about the importance of the legal challenge against both Bills 5 and C-5 and how it is expected to unfold in the court. Before I introduce our panelists, I want to do a brief recap of Bill 5 and C-5 for those needing a refresher. So Bill 5 was passed by the Government of Ontario in June 2025, despite widespread opposition. Bill 5 is a sweeping piece of legislation that eliminates the Endangered Species Act and creates the ability for Cabinet to declare special economic zones that could be exempt from any and all provincial laws and regulations or municipal bylaws. There's more information on our website if you'd like to learn more about the content of the bill itself. Melina will add a link to that in the chat. Bill C-5, the numbers are purely a coincidence, was also passed in June 2025 by the federal government. It allows Cabinet to declare projects of national interest and potentially exempt them from various pieces of legislation, including many environmental protections. Both bills threaten democratic processes, Indigenous rights, and environmental protections. Thankfully, 14 First Nations have brought forward a legal challenge against both bills, which is what our panelists will explain. I'll introduce our panelists and then ask a few starting questions to each of them before we get to your questions. So we are fortunate tonight to be joined by Ramon Kataquapit, founder of Okiniwak. Ramon, you can turn on your camera, please. Ramon is an Omushkego Cree youth leader from Attawapiskat First Nation. He is the founder of Okiniwak Indigenous Youth Movement, inspired by the Seventh Fire prophecy and rooted in youth caretaking responsibilities. He is actively organizing youth and community members across Ontario to respond to Bill 5 and is a member of the Anishinaabe Ashki Oshkonevo Youth Council and Chiefs of Ontario Youth Council. Next is Michel Koostachin, founder of Friends of the Attawapiskat River. Michel Koostachin is a proud Cree member of Attawapiskat First Nation. He's the founder of the grassroots group, the Friends of Attawapiskat River, and is in his final year of the Bachelor of Social Work program at Toronto Metropolitan University. Michel has spent many years practicing trauma-informed care and has been providing wellness services on mental health, addictions, and grief throughout Northern Ontario fly-in communities. For over 20 years, Michel has been Scabish helper in ceremonies. And next we have Carrie Blaise, the founder and legal counsel at LAND. This is the Legal Advocates for Nature's Defense, an environmental law nonprofit based in Northern Ontario that works to advance justice, to protect nature and Indigenous rights. She's an accomplished environmental and Indigenous rights lawyer. Carrie previously worked as a staff lawyer at the Canadian Environmental Law Association. She is a graduate of Osgoode Hall Law School and holds a Master's of Science from the University of Edinburgh. And last, we have Nicholas Daub, who joined Woodward and Company in 2025 as their senior counsel. He has extensive experience in advocacy and public policy with significant work in Indigenous rights, energy and climate change, constitutional law, commercial litigation, professional negligence, class actions, and insurance. Nicholas has served as a senior political advisor at both provincial and federal levels of government. He has appeared before all levels of court in Ontario, the Federal Court of Appeal, various regulatory tribunals, and courts in British Columbia. Now I'll ask each of our panelists a starting question before we open it up to questions from our attendees. But please feel free to begin typing your questions into the Q&A function at the bottom of your screen. So the first question is to Nick. Woodward and Company is the law firm that has launched this legal challenge on behalf of the 14 First Nations. So can you explain to everyone why Woodward and Company launched this legal challenge on behalf of these First Nations? And if all goes well, how that process will unfold?
Yeah. Thanks, Tony. Thanks for the question and for having me. And thanks to everyone for joining tonight. I think this is a really important event. So thanks to the organizers. Just taking a step back in the months that we were talking about the passage of C-5 and Bill 5, I had the opportunity to sit in on a number of meetings with First Nations leadership. And I can tell you three things. Number one, there was extreme disappointment over the exclusion of First Nations and Indigenous peoples from the passage, the deliberation over these bills, how fast they went through without any meaningful Indigenous participation or opportunity for feedback. Number two, there was an intense feeling of lip service to reconciliation. Are we taking a step back from reconciliation in the case of the federal government with the new prime minister, and in the case of Ontario, extreme distress over how the Ford government has treated reconciliation? And the third thing, a real anxiety that history is repeating itself, and that when Ontario and the federal government are talking about speeding through infrastructure development, that it's the lives and the lands and the waters of First Nations and Indigenous peoples that are going to be irreparably harmed, again, without their participation. So my clients, the 14 First Nations that we're talking about, they say they have the right to have a say, to participate in the decisions affecting their lands, lives, waters, that these rights are enshrined in treaty. And these are the treaties where these First Nations agreed to share their lands in the first place. So they should be at the decision-making tables and with a meaningful say in what happens. These rights are protected in the Constitution, and both levels of Crown government, the feds and the province, they operate under the obligation to uphold the honor of the Crown. They're absolutely not doing that when they speed through legislation, and when they say, which is what the federal government says on their website, that these projects, it's not a question of whether they'll take place, it's just figuring out the details of how. So how that is compatible with meaningful Indigenous voice is a question that I can't understand. And what my clients say is there is no answer to it. It's severe damage to reconciliation and a step back, and therefore unconstitutional. So if reconciliation is ever going to take place, my clients say that we've got to do things like what they're asking for in this lawsuit. So if all goes well, this is the second half of Tony's question. What's the desired outcome? What does it look like? My clients are seeking the reversal of the key pieces of the two pieces of legislation that exclude Indigenous voice and allow both levels of Crown government to treat these decisions as done. So these are the provisions that allow cabinet at both levels to speed through projects without the normal regulatory approvals, without the normal triggers for the duty to consult, without effective Indigenous say in whether the projects will proceed. So my clients are seeking a reversal of those provisions as unconstitutional. The form that they're doing it in is important. I might say something quickly about that as well. It's an application, not an action. And what that means is that there's a real hope, there's a real determination here to move things along quickly here. This, we're hoping, is going to be about a year-long process and not a long and dragging typical legal process where there's a trial and it takes 5 or more years. So shorter, more focused, evidence from the nations themselves, evidence from chiefs from each of the nations, how these pieces of legislation affect their lands, the lives of the people in their community, the stress, the anxiety, and the stress and the anxiety that the constant threat of their lives being irreparably disrupted, what that causes. So that's their opportunity for expert evidence, also an important part. So talking about things like impact on species that are important to the way of life, the environment, like Tony was saying, climate change, the psychological impacts, the physical impacts. So doctors and psychologists and so on will have a part to play in this. We're expecting media attention in a case like this, so we're hoping for ripple effects beyond the case itself. This, we're expecting, is going to be a very high-profile case, given that these are the centerpieces of both levels of government, their legislative agendas. So we're expecting media attention on, when it comes down to it, on the central issue of reconciliation. So there's a hope that beyond the four corners of the case, it also has broader impacts. And that's why it's so important. And we're so grateful for interveners like the ones you're going to hear from today, because, of course, it's important to hear from the 14 First Nations themselves. We're hoping other nations elsewhere in Canada will also raise their voices and add to the chorus, interveners as well. This is just such a massive set of policy questions and questions for the future of Canada and the nations that we just see it as crucial for interveners like the ones you're going to hear from. The role that they're going to play and their participation is very welcome. So that's enough for me. Thank you very much.
Thank you, Nick. That was a great overview. Very helpful. So, Mike, from the perspective of the Indigenous grassroots, can you briefly explain why there's so much opposition to these bills from Indigenous peoples?
Thanks, Tony. As interveners, we are concerned, and we have to explain as grassroots what the roles were given, instructed. Everything has their roles and responsibility. It was mentioned that we have a constitution, section 35, under the treaty. As long as the water flows, grass is green, sun shines. And we are here still today. They're going up against something that they're going to use to develop, extracting those minerals, critical minerals. But they're going to impact our livelihood, our environment, our waterways. Our watershed flows downstream from the proposed Ring of Fire. There's a conference right now with BUTAC, more announcements. And we're still sitting at court, waiting for court to come up and explain our side. Tell we are the friends of the court. We're going to explain something. Why we are here. That land, that environment, it's everything's spirit. The red people are the spiritual people. We don't harm anything that we require from the land. We use everything accordingly, or things were set up for us. We call those natural law. Those natural laws that were given to us, those are our instructions. We're symbolic people. And we have to explain that. We have to explain our roles and responsibilities as Neheno, or Four Directions people. We have our own constitution. And that's where I want to explain as intervener within the courts why we want to not challenge, but to be heard, so they make decisions. That's why I practice my ceremonies. I've been a helper for 20 years of their ceremonies. But everything we do is natural. We don't build, hammer, put nail what we want to use. That's the difference of natural law. We have to follow the sun. We can't go backwards when we do something. We have to move forward. So that's what I wanted to share as intervener. We have roles and responsibilities, and that's through our natural law. We only have 4 natural laws, and we follow them. In English.
English, Mike. Carrie, next question's for you. Land has filed an intervention on behalf of Ramon and Mike in this legal challenge. Can you explain what that means and why it is important?
Absolutely. Thanks, Tony, for the question. Ramon for starting us out in a good way, and Mike and Nick for sharing. So the reasons that we're representing Ramon and Mike, who you see this evening in the court challenge, is to be interveners, to be friends of the court, and it's to ensure that their voices as Indigenous grassroots, as land protectors, as youth are heard by the judge. And I think the value in this is something that everyone who has joined us this evening can relate to. It's so important that we hear firsthand from those who stand to be directly impacted by the proposed Ring of Fire, from the rollback of protections that we see in Bill 5 and how it's being implemented. And it's a shared recognition that it's precisely these voices, Ramon and Mike, that we must hear from. And because of a lack of access to justice, it means these grassroots voices, these land protectors, are not often heard by the court. And so it's more than clear that these individuals, their families, their communities stand to be directly impacted. And so there's a critical need for these voices to be before the court, before the judges who are being tasked with interpreting Bill 5 and understanding its true impacts. And so that's where we come in as land. So we're an environmental law nonprofit based in Northern Ontario, and we're finding ways to create space for Indigenous laws to be brought forward, Indigenous grassroots voices to be brought forward, and to give a voice to those who otherwise wouldn't be there before the court. And so it's both an honor for myself to be their legal counsel and a responsibility I take very, very seriously. And now I'll unpack for everyone this evening kind of the legal angle of what we're trying to accomplish. So as you heard, we are proposing to be interveners, and that means we're submitting documents to the court, bringing a motion, and it's the court who will decide whether or not they grant us intervener status as friends of the court. And so we are saying that Ramon and Mike have a genuine interest, a unique perspective that would assist the court in what they have to do in advancing justice. And so as Nick shared, several First Nations have brought the constitutional challenge to Bill 5, and Ramon and Mike are seeking the court's permission to intervene to bring that grassroots land protectors perspective to the challenge. And I guess to back up a little bit, I used to work at Legal Aid, and in that position, I saw firsthand, the lack of access to justice for, those who are on the front lines of, injustices to rights and to the land. And so that's why land was established just a couple of years ago to make sure that those who are most impacted by decisions, and it could be laws like Bill 5, have their voice and have a say in what is being done, because so frequently those who stand to be disproportionately impacted that have the least ability to have their voice heard. And so that's a core part of our founding mandate, to make sure that people and communities have that legal representation when they otherwise wouldn't do so. And so this case is very much about accessing justice as it is upholding constitutional law. And so to kind of close things off before I pass it back to Tony, and then we'll hear from Ramon, I can provide a brief kind of snapshot of the three legal arguments that we're going to raise on behalf of Ramon and Mike. And so the first echoes what Nick was speaking to about reconciliation. So we're arguing that the Crown's ultimate purpose is reconciliation, and Bill 5 is a commitment of Ontario's reconciliation, or commitment to actually move forward with reconciliation. And not surprisingly, we're arguing that Ontario has adopted a very impoverished view of reconciliation. And so we're asking the court to recognize their role in advancing reconciliation done in a way that upholds the Truth and Reconciliation Commission's call to action, which recognizes the UN Declaration on the Rights of Indigenous People as that framework for how do we actually get there. And our second argument is around, respectful reconciliation, and how we get there cannot be in a narrow jurisdictional paradigm. It's not just Crown law, but it includes Indigenous laws and worldviews. And so, as Mike so thoughtfully, introduced us to, Cree natural law tells us there are natural laws from Creator to have strength, to share, to be kind, to be honest, and that law and that system of legal traditions is what we're bringing forward in our materials. And then the third and final argument we're going to bring to the court is that Bill 5 raises serious concerns under Section 15 of the Charter, which is the right to equality. And we're arguing that Bill 5 disproportionately exposes Indigenous communities to environmental harms while weakening, protections to safeguard them, and this amounts to environmental racism. And so to close, before I pass things back to Tony again, we truly hope the court will see what we try to instill in all the audiences we address. Ramon and I have been with Mike in Kingston addressing audiences in Toronto, and we're making plans for another summer tour to get out to more communities across the province. But we want to share that Indigenous knowledge keepers and youth leaders have direct lived experience advocating for their rights and the protection of the environment, both for current and future generations. And we have to ensure that decisions and laws that are made and passed are done in a way that aligns with Indigenous natural law and knowledge, so that there is respect for Indigenous rights and inherent rights to protect nature. Miigwech, thank you for having me this evening.
Thanks, Barry. And question for Ramon. Why did you personally feel that you had to intervene in this legal challenge?
Thank you for the question, Tony. The reason why I joined Carrie and the other First Nations is because I've already picked up doing this work for a few years as a youth. And when Bill 5 had passed, that's when I knew that it was time for us to spring up again and for the youth to stand up. Because in my time as a youth council member, I've seen a lot of my leadership talk about that fire and trying to make change, but I see that they're starting to be scarred and damaged from a long time of fighting. And we weren't seeing the responses that we should have from our leadership, a strong response for what's important to us. That's what I wanted to see from my leaders. And even though there's bits and pieces, flashes of history there, I didn't see it. I knew then and there that it was time for the youth to start making these strong responses. And shortly after the bill passed, you've seen youth movements come to life everywhere. Like my cousin with Here We Stand, Ramon Kataquapit, going up the river to create an encampment. And also other youth groups like Youth Rising Together, and also Mamo with Busigos, I can't remember the full one, but they walked from Timmins to Toronto, 700 kilometers. And along with that was us, Okiniwak. And I have my staff right here. The name Okiniwak stands for the leading youth. And it was created around a sacred fire. And I want to give a little bit of a story and a background of how we were created and how it connects to joining in the court case as interveners. I actually was able to get my way into the Ontario legislature along with my grand chiefs and leadership as we watched the bill be read over to be passed. And when it passed, I saw the look in my leadership's face, very distraught. And I saw the look on Saul's face as well, and those who voted against the bill. Then and there, I knew exactly how this majority government viewed my leadership, as if we're something to consult afterwards and not beforehand when a bill is being made about our futures. And I seen that look of desperation on the leadership too. And they had strong talking points when the media came to them after. You will see us out there on the ground. You will face opposition. But then after they made their comments, they left. But there was a group of people, all from different nations in Toronto, that gathered around outside the legislature to show their support. And the majority of them were youth, women, and two-spirit plus kin. They were out there, and I felt disappointed to see my leadership leave. So I said to myself, if they're not going to do it, then I will. So I stayed out there with them. And over the course of those next few days, a sacred fire was established outside of Queen's Park. And a lot of people came to that fire, and a lot of ideas were born around that sacred fire. And that's how Okiniwak was born, a youth-led movement to not only unify youth from across Ontario, the nation, and one day internationally, to speak from youth to youth, with youth, for youth, from youth, so that we have a one-to-one voice from each other without having to go through a political organization or through a government to lobby or speak for us. We decided that we had enough and that we're going to lead ourselves, which is why Okiniwak is the leading youth, to lead together. And since that course, before we really got to meet Carrie, we held huge rallies. We held a rally on July 1st outside of Queen's Park. We had hundreds and hundreds of youth come from different First Nations from down south and up north, and even those that live in the city hubs. And they came and they spoke. And we heard their voice of how they want to protect the land because they know how sacred it is up there. The breathing lands, it's the lungs of Ontario, it's the lungs of Canada, it's the lungs of North America. But it's our home too. And a lot of communities that may have gone through mining that has affected their waters and the animals and the nature around them, they know what's coming for us. And we've also had a history of that around Attawapiskat. But to tie back to the question, after mobilizing in different areas in Toronto, we mobilized in Ottawa outside of the Prime Ministers and Chiefs meeting, and we showed our presence right there outside the Canadian Museum of History. We held it in our First Nations up north, but we also brought it down south in Kingston. And that's where we met Carrie and Land, and they offered that platform down south where we probably wouldn't usually have been invited to before that. or had a platform down there, but they created one for us to share what's going on in Treaty 9. And I remember Carrie asking me after we had a crazy week of not only going on out on the pond, uh, boating on the river, or being able to meet with your TV or Queen's University, or speaking with other land defenders and other First Nations like Tananaga, but also holding a benefit concert in between, telling people what's going on up there in Treaty Number 9 territory, but also, having some fun in between, because not everything has to be so serious. But just to continue on, we also held a lecture there at the Queen's University Isabel Barter Center. And we were able to expand, thanks to Carrie, of what we thought advocacy was as a grassroots group. And that's when it was introduced to us that we could be interveners. And Carrie had asked me. And, I never really thought about that before. And it's something that, it took me a little bit to think about. But the number one reason that led me to become an intervener was so that we can broaden our horizon and how we respond. Because sometimes as a grassroots, we can only go one or two routes before we might start to dwindle out or diminish, because people have a certain view of grassroots groups that were too much or that were not recognized. So in a way, it gave us legitimacy in another corner that I never thought that we would be able to have legitimacy in, by doing things on the ground, but also bringing it to the court and being a part of that. And with also another idea that we want to make Okiniwak become a political organization to uphold and make sure that these rights are respected with the government. So we're attacking it from all angles and even through social media. And yeah, we know how important it is to have the youth voice included in these spaces that usually we would have to funnel this through an organization or chief, or through an MPP or MP, or even to the prime minister that I met once on my time as a Nan Youth Council member. I asked him for clean water for my community, and it didn't come. Some of these things really solidified in me that it's up for us youth to speak for ourselves, which is exactly why I believe it's important for us to be a part of this court case as an intervener. I feel like I'm talking for too long. Oh my gosh. Okay.
No, that's
Thank you.
great, Ramon Miigwech, and thank you for sharing. So now we're going to open it up to questions from the attendees, and I see we've actually got quite a few already in the Q&A. So I'll get us started here with the first question. And as I think all of our panelists know, the big annual mining conference is also happening this week in Toronto, and there's been a series of announcements from the provincial government. So the question is, and this is kind of to any of the panelists who want to provide a response, why and what are Doug Ford's motives behind his recent news release that he no longer needs Bill 5 to mine and build in the Ring of Fire? I think we've seen some announcements that the roads are being expedited, the process, and the premier is now saying Bill 5 isn't necessary to do it. So, I guess. And to any of the panelists, any thoughts on that one?
Maybe I can take. Sorry, Ramon did. No, please, Ramon.
Go ahead, Nick, and then we'll go to Ramon.
I'll take a swing, but I got to confess, I'm out of the office this week, so I haven't read the most recent press releases. I've been trying to avoid newspapers and things the past few days. I think it's really important. I think it's important. Well, let me say it. I think all this stuff with Trump, all this stuff with national crisis, it's all a pretext because Doug Ford and the Conservatives have been talking about developing the Ring of Fire in particular for as long as they've been in power. So for the past 8 years, it's been one of their priorities. And so, you know, they seem to be willing to use any excuse and any lever available to them to deliver on that priority. And so I don't know how many people there are baseball fans. I'm a baseball fan. When I was watching the World Series, every commercial break, the Conservatives had an ad that was beautiful, pristine, Treaty 9 wilderness, talking about how development of the Ring of Fire is going to fund Ontario's hospitals and deliver world-class healthcare. So, they'll say anything. And it's not entirely clear why this has been such a priority. There may be others who have ideas or are more willing to speculate than I am, but they seem to be willing to use all levers and every lever and all levers available. But what's remained constant is that there has been a relentless pressure on the area First Nations to get out of the way and to let this happen, and a denigration of their consultation rights and the right to participate in these projects. So, short answer, I obviously can't get in the mind of Doug Ford, and there are all sorts of different ways that they can try to advance development. Bill 5 isn't the only way. It seems to be the most convenient way at the moment. And I guess one thing I would say is there is an anxiety that there's a divide and conquer strategy at work here. And so, bit by bit, and an attempt to exhaust both the will to resist and the resources of First Nations, the ability to stand up to this. So, inch by inch and divide and conquer seem to be some of the strategies at work here. So, when we're talking about roads getting closer to the ultimate development that will have irreparable impact on the kinds of things that you've heard about today, it's a shifting strategy, and it makes it more difficult to defend against. But my hunch is that Bill 5, regardless of what he's saying this week, is likely to remain a centerpiece of the strategy, or an important part of the strategy, no matter exactly how it shakes out in the end.
Ramon, do you have anything you wanted to add?
I was just wondering if you can repeat the question, because I understand what they're asking, but just word by word.
Yeah, so why and what are Doug Ford's motives behind the news releases you've seen this week stating that he no longer needs Bill 5 to mine and build in the Ring of Fire?
We actually took part of a press conference with Nishkanaga. We're able to support them and stand with them because they had a response to Ford's conference here. That's happened alongside PDAC, which is another reason why we're here too, to show our presence. But with the words from Ford, there's a few talking points that he spoke about that they're just really bizarre. And the ones that really stick out to me is that he kept speaking about where he spoke to chiefs, to First Nations, to youth. Especially, he emphasized youth, saying that they're very happy for this development and they want to see these things come the way. But speaking to Martin Falls and Webekwe, you can't say that you've spoken to the whole, because the Ring of Fire encompasses a lot of communities, especially including Nishkanaga and Attawapiskat. And when he says that he no longer needs Bill 5, that's absolute nonsense. It's ridiculous. He needed Bill 5 in order to strong arm our communities to make a decision on the roads leading up to the Ring of Fire. Bill 5 is going to stay because that's what's giving them the powers of leverage over what we have with our treaty jurisdiction. Because with Bill 5, it gives them powers to override not only environmental regulations, but it gives them some one-step process to where they only have to deal with one community, one or two communities to create an environmental impact assessment, even though it encompasses a lot of communities to be impacted. It's just to fast track things. And when you fast track things, it's good things don't happen. You know, there's obviously a bigger reason behind his intentions of not just trying to unlock the Ring of Fire, but higher powers in him putting pressure onto him to unlock the Ring of Fire. It's definitely an international thing of why he's pushing so fast and so hard and lying so easily there in his press conferences. Because of what happened, their selling point, their talking point is because of Donald Trump and the tariffs. And that they need to create a new trade partnership agreement with another country, most notably China, for things like EV vehicles. But I really think that it's another layer to it that's not really talked about, is the erosion of our treaty and our inherent jurisdiction to that land up there. I think there's a lot of different things in this ball game that Ford is playing, of the reason why they're trying to make sure that this development happens so quick and so fast, to the point that they need to create a bill to group us all into one thing, even though our communities are so diverse, have different needs, different wants. But I see that we're only respected if we have something to give up. And that's something that I'm sick of seeing with the government towards my people, which is exactly why we're doing what we're doing and not bending, but speaking as a nation. Because with the way that Bill 5 is going, this isn't a nation-to-nation agreement. It's conformity. It's to ask us to bend down and take what we can, or else, or to compromise. They don't want that. They'll lose money from doing that. Things will take time doing that. But I really think that there's higher powers at play behind Ford's decisions. Because honestly, that guy doesn't seem that bright. I'm sorry about that comment, but it's the truth. And yeah, English.
Thanks, Ramon. I see lots of great questions in the Q&A, and I'll try to get to as many of them as possible. So I think I'll kind of direct the next few at one particular panelist. So Mike, question for you. How can Indigenous people move forward now that Bill 5 has passed?
You know, I've seen the poverty in our First Nations communities. There's lack of education within our young people, and the poverty line. And I've been observant how our proponents being treated, and there's stuff that they're getting now, and I've seen work in the communities that we're lacking our own identities. The language is there, it's very strong, but the spiritual is missing. If we understand those natural laws, we would protect our rights, we would protect our land, our traditions, our traditional territories. But with the disruption of the residential school, we're still being impacted. So I see a lot of tokenisms within our leadership. And they like that. They want to be seen, hold tangible stuff. Just this week alone, I see these guys at the hockey games. Where's our young people? Our young people is still impacted. So they don't know their own identity, culture. So I wish our young people get that education, not just the mainstream college or university. We have our own schools. Late elder Peter O'Cheese said, when we're in ceremony, he calls it Indian school. Those ceremonies that we conduct to take part, be part. And a lot of our people, our leadership, are not in those ceremonies. So the approach, what Duckford is doing is they divide and conquer, like what they did with Attawapiskat River. We went through that, and we didn't prosper. They promised a lot of stuff, prosperity, and nothing to show for. We have 5 declared emergencies: housing, suicide, employment. So our healthcare system is not 100%. So what I like to see is what we're saying is, do better. We need better housing. So everything is backlogged. A water system. If you look at the Saskatchewan First Nation, their infrastructure, the contamination, the contaminants that were there, even out of Wapiskat, we have toxins that were there that's cancer causing. So we need better infrastructure. It would be nice to be part of the proponents, right? But we're not there. We've been divided. English.
Thanks, Mike. Next question is for Nick. I'm going to combine two here. Can you explain the difference between an application and an action? And then is this particular one application or two?
Yeah, thanks for the question. It's one application. So in the same application, the 14 nations are challenging both the pieces of legislation. There's a lot of overlap in the issues, some small differences, but there's enough in common that it made sense to put them both in the same application. Just it makes for a more efficient process. The biggest difference between an application and an action is an application is all paper-based, so there's still evidence, but it's all through affidavits, expert reports, it's all in writing, versus an action that's a trial. It's live witnesses, everyone testifies in person. The application, they almost always go a lot faster because there are just fewer procedural hoops to jump through. When you're supposed to use an application instead of an action is when the parties are saying the facts are clearer. It's less important for witnesses to show up and people and either the judge or the jury to hear different versions of what happened. So here we're saying the facts are pretty straightforward. The legislation is what it is, and what what the chiefs and the experts are saying is relatively straightforward. It's not a he said, she said kind of situation. So we say it's focused enough and the facts are straightforward enough that we can make use of that paper-based, more efficient process.
Nick. Carrie, I think you'll have some thoughts on this next one. So, how does this legal action impact, or how could it impact the government's plans to start building the roads to the Ring of Fire, essentially this spring?
Yeah, great question. And I think Nick alluded to it earlier. The proposed Ring of Fire has been talked about for years and years and years. And so right now there's a whole slew of various projects that are ongoing and at various stages that decisions have to be made before any development can occur. And so there are public comment opportunities, I should note, right now for the Martin Falls and the Webber Supply Road projects. And they are inviting public comments on that. And so while that is happening, we are seeing the government systematically remove the decision-making points that used to be in place that would have allowed for, studying of effects, public participation, that flow of information, so we actually know what's being proposed before it happens. And so Bill 5, there was many schedules to it, but one of the schedules, many of you probably recall, it terminated an environmental assessment for the Eagle's Nest mine, and the Eagle's Nest mine is one of the largest mines that's proposed within the Ring of Fire. And since Bill 5, there was C-5, and I see someone else in the chat talking about C-15. What those pieces of legislation do, it's giving Canada and Ontario the power to harmonize or substitute or combine essentially their laws and regulations into one process. However, Ontario never had environmental assessments for mining projects to begin with. There was a huge gap in the law and a huge gap in actually having those safeguards. And so right now what we're seeing is projects are moving ahead. It can be the mine sites themselves. It can be, the 40,000 plus claims that have been staked for the mines that have not gone ahead without consent. So, at some point, at what point will the government hear the hundreds, the thousands of voices? I know Ontario Nature's Action Alert has gotten thousands of sign-ons, and ours has as well. And for the government to recognize there are voices, many voices from across the province who are not in favor of the current trajectory, and just to note that there are a few decision-making points still open. Public comments, those public comment periods remain open. I can share a link in the chat box too, if people want to learn more. But right now, Ford is saying that it'll be shovels in the ground this summer. I would not. I think there's a lot of misinformation behind that, and a lot of debunking that has to happen around his rhetoric for critical minerals in the Ring of Fire.
Thanks, Carrie. This question here around actively engaging media outlets from all political perspectives, and that the government's in power. There's certain media that forms it, so they'll simply ignore Bill 5 and C-5. I think I'll kind of take this one. We did see extensive coverage of Bill 5 and C-5 when they were introduced across media platforms. We live in an age where news flies fast, the attention span, there's so much going on in the world right now that it becomes hard to focus on these issues, particularly at home. But as Nick kind of alluded to earlier, when this actually does go to court, there's an opportunity to bring attention back to it and kind of raise those issues of the direction that we want to go as a country and as a province. And Ontario Nature, Land, and Okiniwak, will continue to host events to continue to raise these issues and provide opportunities for communities to have their voices heard. So it's hard to break through the noise sometimes, but this isn't too important to ignore. Um, guess question for Ramon. The lack of a full impact assessment for the Ring of Fire. Any thoughts on kind of how that's affecting um, First Nations up in that area?
There's a few ways I can speak on this, whether it's the social impacts or the environmental impacts. Socially, not including all First Nations that are within the surrounding area within an impact assessment is another divide and conquer tactic. And environmentally, do you know how they will power the mines, especially Eagle's Nest and ones to follow? Is with the transmission line. It's called the Greenstone Transmission Line. It's going to start building up from down south to Martin Falls, Webequie, to the James Bay lowlands. And it will be powered from damming. Damming is very significant in affecting the environment and our rivers. So when I see our communities not included that are surrounding the Ring of Fire in this impact assessment, it not only harms us socially, harms us through legislation, harms us through divide and conquer, but it harms the environment. And it also harms the spirit and the relationship that we have with each other, to the land, and to the government. This isn't leading in good faith. It's leading through conformity, sorry. And yeah, anyways.
Thanks. Nick, you want to add something?
I just add the nerdy lawyer point, and it I think complements what Ramon was just saying. This is one of the best, this is one of the worst examples of both levels of Crown government talking out of both sides of their mouths. Because what they said last summer was, don't worry about how fast we're moving. Don't worry about the fact that we haven't really consulted with Indigenous peoples, because there's always the duty to consult. And so whenever a big decision comes along, we're going to consult with Indigenous people. So everybody calm down. Nothing to see here. And then if you look closely at the two pieces of legislation, it's the Impact Assessment Act revisions that you see at the federal level, and there are examples at the provincial level. Um, they are stripping out the kinds of reviews and decision points that used to give rise to the duty to consult. So, in other words, because there isn't that phase that Ramon's just speaking about, all the real life consequences, because there isn't that review anymore, there's no constitutional trigger for the duty to consult, which used to be an important way for First Nations to get their voices heard, to make sure they were getting their hands on the right information, and so on. There are lots of similar examples on the Ontario side that they're getting rid of. Carrie spoke about some of this. Environmental protections, archaeological protections, so think burial grounds, like making sure that there's been a proper review undertaken, species protections, all of these things that used to trigger a duty to consult when there was a decision and government sort of thinking about giving approvals. These are all gone, so opportunities for Indigenous engagement are really stripped away. So bottom line, this is a good example of, or a terrible example of both levels of government talking out of both sides of their mouth, and why you shouldn't believe them when they say, don't worry about it, we're going to consult with Indigenous peoples. They want to, what these two pieces of legislation do is allow them to hold all the cards on the ultimate decision of whether these projects take place, and they just enhance that power in the cases of both levels of government.
That's a good segue, I guess, to the next question, Carrie, of what are the options for potential like injunctions with some of these proposed developments that are essentially being expedited without proper consultation.
Yeah, so that is the crux of the application as well. I know there's another question around, are Bill 5 and C-5 constitutional? And so that is what is being argued, is that these laws are not constitutional, and by their very status, if they're not valid laws, if they're not constitutional, they're not valid laws in that way. And so maybe I'll actually turn it over to Nick to speak more to injunctions and that as a potential remedy, and how that might be used in this court challenge.
Yeah, that's a tough question, and it's an active question. So, yeah, like you can see that the nations had it in mind as a possibility when we put together the application. I mean, the question is going to be, is there something that one level of Crown government or the other is doing that is going to cause irreparable harm? That is the central part of the injunction test. There are other aspects, but are they taking that step that are going to forever damage the waters or the health or the species or any number of things? And maybe that's the roads, maybe that's a step further along the line to opening up the mine. So, like, I guess in a way I'm dodging the question because, it hasn't been decided yet. This application is one possible route, but there are other possible routes if we get to that point, and the best possible route, that'll totally depend on exactly, what it is that's the big problem that's arisen. Hopefully that's not too much dodging the question.
Yeah, it's a tough question, but I think that's helpful context. I see a lot of questions too about, what can I do or how can I help, those sorts of things. We'll get to that kind of as we wrap up. But I want to try to squeeze a couple more questions in here. Apologies again, we won't be able to get to all of them. But this question, I guess it could be kind of for anyone that wants to take it. Another aspect of Bill 5 is the ability to bypass archaeological assessment requirements under the Heritage Act. And so I guess the question is how that affects the Crown's ability to meaningfully uphold Section 35 rights and Indigenous stewardship over culturally and ecologically significant areas. So, I'll open that up. That's also a big one, but a very important one.
Maybe I'll be quick, but maybe I could take the first crack at it. That's what I think Ramon and I were talking about before. That's the provincial equivalent to what the feds are doing with the impact assessment. Stripping out phase 1. So Ontario is stripping out what used to be the normal approval processes for archaeological reviews. You're exactly right. And that used to, because the provincial government was making a decision whether the project passed the test or not, that used to be something that triggered the duty to consult under Section 35 of the Constitution. And so by getting rid of that review, they're getting rid of an opportunity for Indigenous participation, for information gathering and sharing, for all of that. There's a case from the Supreme Court in 2018 called Mikisew Cree, and it leaves the door wide open on this sort of issue. They were focused on other questions. So the judges left this question for another day. But what Justice Karakatsanis said is this is exactly the kind of thing that might be contrary to the duty of the crown, or I'm sorry, the honor of the crown. And if that's and what she meant by that was if you are degrading the ability of Indigenous peoples, of First Nations to uphold and engage on their constitutional rights, like if you're getting sneaky and effectively deteriorating their position, that is a constitutional violation. She said probably. And so the Supreme Court hasn't squarely decided that question yet, but they've left the door wide open. So the example you're raising is squarely there. Same thing with the environmental changes, same thing with the species protection changes, and same thing with the impact assessment changes. Like that is a very active question that is ripe for the Supreme Court to follow through on those initial thoughts.
Thanks. Mike, did you want to add something?
Yeah, Tony, like Nick said, that they won't consider anything sacred around the rivers, burial sites. So just inform our viewers, they're where they're going to cross. It's a sacred site. So that's why people are up there trying to protect. They will protect the crossings. That crossing where it's being proposed in the Attawapiskat River. So they won't consider it legally. But us First Nations, that's our duty, responsibility to protect the sacred site. So that's why our young people are rising up. So with our ancestors that are buried along the rivers, they have to be protected. You guys.
Okay, so I think we're gonna kind of get some roundtable thoughts from each of our panelists on what is one action that each of you would suggest our attendees take away from tonight? I think we had a lot of questions about that we didn't get to because I was going to give you guys this opportunity to share one thing you would suggest all of our attendees take away and commit to do. So I'll go each of you in turn. So we'll start with Ramon.
I gotta go first. Oh my gosh.
Sorry.
Okay. There's one thing that I always try to share at everywhere that I'm able to share my voice at, whether if it's at rallies, at chiefs assemblies, if I'm able to address government or to our youth and our members, our people, is to believe in your voice. Of course, I do want to say that we can have support for Okiniwak, for you to come and stand with us when we do mobilize in different cities or different First Nations, or if it's through social media. The one thing that I want to inspire is for you to take a step as an individual, because that way, let's just say one day, if anything happens to me or someone else that's leading this charge, it's happening all over. And I want to see people find that courage within themselves to find that leader that's sitting there to take the next step. You know, how I got here, and it's only been barely over half a year, is I just decided to start taking the next steps, even though I had no clue where I was going. Sometimes it felt like I had a blindfold over my eyes. A lot of my thoughts were telling me, oh, I can't do this, or I'm not qualified, or I don't know enough, or that I'm not ready. But then my heart is something that led me through those situations to be able to start taking action. Because our brain will fail us a lot of the times, but our heart, when we speak from our heart and we move with our heart, we move with love, we move with spirit, you can move mountains, you can move the moon. Because I know that when we're walking as people, it's not just an individual. I know that my ancestors are with me. I know that my Mushrooms looking over us. I know that the future generations that haven't been born yet are waiting for us to walk to them. We know that this path is being led out, but it's up to us to take the next step. And those next steps eventually lead somewhere, even though it might seem like you're barely moving. And that's the one thing that I want people to take away from, on top of the information that we shared here, is to take the next step in what you think you want to do with what we provided or what you've already known. Because it takes a lot of us to stand together. And it takes a lot of courage to be yourself and to actually speak and use your words. I've known because I dealt with this. I thought nobody would care to what I had to say or what I thought the future should be like. And I always put myself down. I was in a box. And these boxes were put over me from things that I didn't even cause. From just being born in this world, I was put in a box and being labeled as an Indigenous person that has this, that, and the thirds from residential schools, because I come from a long line of assimilation, but also gifts too. You know, my grandparents went to residential school. My mom is a day school survivor and also a boarding home survivor. You know, I'm part of that first generation that's outside of that. I was able to choose where I could go to school. I was able to leave the reserve and find some education. You know, and it took a lot of courage to do these things, and it's not easy, but I really want to just inspire people to start taking those steps, whether if it's you mobilizing in your own community or you working with a environmentalist group that has started in your community or nearby to you, or starting anything of yourself, or just walking as an individual and remembering that we should be walking as a people, because unity, I found out the true weight of trying to achieve unity this last year. Because we've tried it. I've tried it in rooms with our youth. I tried it in rooms with our chiefs. All different mindsets, all different backgrounds. But I know that something that we have is common with each other is to be respected as people and to find a base level that we can all agree on is, you know, if we can relate it back to Phil 5 is free, prior, informed consent. But for me personally, I think it's just love, showing love to one another, showing love to the land that created the people, and what created that land, the creator. You know, we're like artwork of the land. Everyone on this earth, you're all indigenous to somewhere. We just still carry those teachings. You know, there's a reason why I carry the staff. You know, it's represents an agreement with creator when we're put on this earth. And we still honor that agreement, because everywhere we, with the First Nations people, we use sticks. We use sticks for our teepees. We use sticks for our flag poles. We use sticks for our staffs, sticks for the drumsticks. You know, it represents our relationship to Mother Nature, our relationship to the Creator, but also our relationship to ourselves. So I think the bottom line that we can all find is just love one another, even though you may not agree, even though you may not have the same opinions, even if you may want something else than the next First Nation. I know that we all can find that bottom level. And to relate this back to Bill 5, it's not leading with love. It's not leading with good faith. It's not leading with respect. And sometimes it's not the biggest answers. It's the most simplest one. Yeah.
Thank you, Ramon. That was very powerful. Thank you. I think this is no particular order. Same question. One is one action you'd suggest our attendees take away from tonight, and go to Carrie next.
Thanks, Tony. So I'm going to build on what Ramon said, which is, to use your voice and to say, use your voice to keep asking questions and having these conversations. So you've already taken that first step tonight. And I think it's critical, like the questions that didn't get answered tonight. We hear Premier Ford saying, well, I didn't need Bill 5. I can just do what I want anyways. I didn't even have to use Bill 5. But yet behind the scenes, he is passing regulations. The special economic zone reg came out January 1st, but we were all, away on holiday and came back from holiday and that regulation had passed. So it's asking questions so that we don't fall into the trap of thinking Bill 5 or other laws like it have gone away. So I hope the one action we can all take is to not be silent, keep asking questions, keep having these conversations, and that is together how we can build our voice and the courage to keep it going. Thanks, everyone.
Thanks, Carrie. Nick, one action you think our attendees should take away from tonight?
Yeah, I didn't want to go first either, but now I don't want to go third after Ramon and Carrie. It's a tough act to follow. So, I mean, the easy short answer, I'll give a short answer and then maybe the easy short answer is Ramon, Carrie, and Mike are doing amazing work, like anything, and Tony and Ontario, like everyone you're seeing is doing amazing work. Anything you can do to support them, I think would be amazing. If you're not in a position to support them, it's a crazy world at the moment. And someone asked the question about media attention. It's a crazy world at the moment. There is so much going on. But among the crazy things are these two pieces of legislation. Both of them have parts of them that say whenever cabinet feels like it, not even the legislature, whenever cabinet in secret feels like it, they can say the normal laws don't apply for major development anywhere in Ontario or anywhere in Canada. And that is a massive shift in how we've thought about not just Indigenous engagement, not just environmental protections, species protections, archaeological protections. It's also a massive shift in how we think about democracy and how we think about how everyone's voice should be considered, as opposed to just a very small number of people deciding these big questions on their own, and we don't know always for what reason. I mean, we don't know why the Ring of Fire is so important to Doug Ford, and there is even less of a chance that we will know if all of it takes place behind closed cabinet doors. So you could support the people on this Zoom who are spending a lot of time and energy working towards bringing attention to these issues and trying to make sure that the rights of those affected are upheld and respected. Or, to my mind, it's a bad thing that our communities, that all of us aren't talking about these issues more, that there aren't more of us who are aware of them and writing to our elected representatives, or just kitchen table conversations, letters to the newspapers you read, just increasing the volume on this so that the two levels of government aren't allowed to do this without any sort of consequence or people paying attention. So that's my short answer and my long answer. So sorry for having to.
And Mike, same question to you.
Yeah, with that legislation, both the provincial and federal governments, they have to use paper to pass something, to go after something. When we already have those laws within the First Nations, we have natural laws. I don't need a paper to say to protect my land. I would be there already. I tell people, I share people, we're not protesters, we're protectors. So that legislation, that paper, it's got no brain, it's got no ears, no eyes. no mouth, no arms, no legs. And it's giving people power to go destroy something on stolen land. That's not their land. That's the reminder that we have to inform. We have to protect that water. It's the prophecies that were given to us, that water is going to be poisoned. And our water, we use our waterways. The animals, they swim. They land on water. They walk on water. They drink the water. And that's what we do also. We're 70% water, and we need that. And we have to protect it in our area. So those natural laws, I want to share with others. That's why I'm being part of the intervenor in the courts to explain that. You guys.
Thanks, Mike. So yeah, I'll kind of wrap us up here. I think one of the things you've heard some things, keep making your voice heard, stand with groups like Ramon's, like Mike's, like Carrie's, like Ontario Nature. We have lots of resources and, need as many voices as possible. Keep making your voice heard to elected officials. I believe Melina already dropped it in the chat. You may have seen Ontario Nature does have an active fundraising appeal with a very generous matching donation of 25,000 from our board chair. That money is being used to directly support this legal challenge, and will continue to support events with Ramon, Mike, and Carrie, and to continue to raise these issues. So please, if you are able, consider making a donation to support this legal challenge directly. And then you will get that link again when you get the webinar recording. I want to thank all of our panelists tonight. This was great, very inspiring and illuminating. And thank you to all of our attendees for coming tonight and your thoughtful questions. If there's something we didn't get to, please, reach out and we'll do our best to get as many responses as we can. And as I said, you will receive the recording of this webinar, so please share that widely. And before we end the webinar, I'm going to ask Ramon to provide us a closing. Miigwech, Ramon. It was wonderful. And thank you, everyone, and have a good night.